When the trial begins, the judge will rap the gavel and state, "Court is now in session for the case of the government v. Hale." The judge will then look directly at the prosecution and ask, "What says the prosecution?" At this point, the attorneys of the prosecution should stand and respond with "Ready, Your Honor." The judge will then look at the defense and ask, "What says the defense?" At this point, the attorneys of the defense should stand and respond with, "Ready, Your Honor." Court is now in session for the case of the government versus Hale. What says the prosecution?
Prosecution is ready, Your Honor.
And what says the defense?
Defense is ready, Your Honor.
After opening statements, the judge will ask the prosecution to call their first witness to the stand. The prosecuting attorney should stand and call their first witness, but prior to moving about the courtroom, the attorney must always ask for freedom of the court. Prosecution, are you prepared to call your first witness?
Yes, Your Honor. The prosecution calls Dr. Elizabeth Leitner to the stand. May I have freedom of the court?
You may. An expert witness is a person who is permitted to testify at a trial because of special knowledge or proficiency in a particular field that is relevant to the case. A witness is not automatically tendered as an expert, so it is your job as the attorney to provide sufficient evidence as to why they should be entered. In order to do so, you should call the witness to the stand and begin establishing their credibility and experience. In order to do so, you should ask questions like, where did you attend college? What did you study? After college, how long have you been in your field? After establishing sufficient credibility and experience, you should ask the judge to enter them as an expert. The judge will then ask the opposing counsel if they have any objections. If the opposing counsel fails to provide any argument as to why the witness should be entered as an expert, then the witness will be entered.
Please state your name for the court, spelling the last name for the record.
Elizabeth Leitner, Leitner.
And Ms. Leitner, where did you go to college?
I went to Duke University.
And did you pursue your education after graduating from Duke?
Yes. I went to med school, followed by my residency, and now I'm in my fellowship.
Okay, and what did you study in medical school?
I'm mainly focused on DNA methylation and cancer research.
And do you have any experience studying this, say, in a laboratory?
Yes. Actually, I have a published paper, which was after 10 years of lab research.
Thank you. And at this time, Your Honor, the prosecution moves to tender Dr. Elizabeth Leitner in as an expert in biochemistry with a specialization in DNA sequencing.
Are there any objections?
No, Your Honor.
She is so entered. Evidence is proof used during a trial to improve your side of the case. All of the evidence will be displayed in front of the bailiff at the front of the courtroom. If you want to use a piece of evidence during questioning to improve a point, you should begin by asking the judge to approach the bench. After the judge grants you permission to approach the bench, you should then retrieve the exhibit and show the opposing counsel the document. After showing the opposing counsel, you should then ask to approach the witness. The judge will always ask your purpose in approaching the witness, and you can respond with identification and clarification purposes. After approaching the witness, you should begin by establishing the credibility of the exhibit. For example, you can ask 3 questions. Do you recognize this document? What is this document, and has it been changed or altered in any way? After establishing sufficient credibility of the exhibit, you should then ask the judge to enter it as evidence. The judge will then ask the opposing counsel if they have any arguments. If the opposing counsel has an argument, then it is your job as the attorney to argue the merit of the exhibit and to why it should be entered. After the judge hears the arguments, the judge will determine whether or not the exhibit will be entered as evidence.
Thank you, Ms. Leitner. And at this time, Your Honor, may I approach the bench to retrieve what has been previously marked as Exhibit 4?
You may.
Let the record reflect that I am showing the opposing counsel what has been previously marked as Exhibit 4. May I approach the witness for identification and verification purposes?
You may.
Do you recognize this document?
I do.
And how do you recognize this document?
This is a DNA sequence of a specific gene.
And has it been changed and altered in any way?
No.
Your Honor, at this time, the prosecution moves to enter what has been previously marked as Exhibit 4 and as Prosecution Exhibit A.
Are there any objections?
No, Your Honor.
Seeing that there were no objections, it is so entered. When a witness makes a statement during an examination that contradicts their deposition, then it is grounds for impeachment. After the witness makes a contradictory statement, you should ask them to clarify their statement. After they clarify, you should ask the judge to approach the bench to retrieve their deposition. After the judge grants you permission to approach the bench, you should retrieve the document and then show the opposing counsel. After showing the opposing counsel, you should ask the judge to approach the witness. The judge will always ask you your purpose in approaching the witness, and you should always respond with identification and clarification purposes. After approaching the witness, you should begin by establishing the credibility of the deposition. For example, you can ask questions like, "This is your sworn statement that you signed on December 7th, correct? And this is your signature on the back approving that all of the statements in this deposition are accurate and true, correct? And this document hasn't been changed or altered in any way, has it?" After establishing sufficient credibility of the deposition, you should then ask the witness to read silently as you read aloud. At this point, you should read aloud the inconsistent statement. And once you have done so, you have sufficiently impeached the witness.
Thank you, Ms. Leitner. At this time, the prosecution has no further questions, and I'd like to reserve the remainder of my time for a possible redirect.
That is your right. Will there be a cross?
Yes, Your Honor. May I have freedom of the court?
You may.
Dr. Leitner, in your statement you said that you had 10 years of lab research. Is that correct?
Yes,
Did you prepare a statement for today?
I did.
Your Honor, may I please approach the bench to receive what has been previously marked as Dr. Leitner's affidavit?
You may.
Let the record reflect I'm showing opposing counsel Dr. Leitner's affidavit.
Please ask to approach the witness.
Your Honor, may I approach the witness for identification and clarification purposes?
You may.
Dr. Leitner, what is this?
This is my affidavit.
And is it a fair and accurate representation of it?
Yes.
And you signed it, didn't you?
Yes.
And it's been sworn into court today.
Yes.
And in your affidavit right here, it says that you studied in a lab for 5 years. Is that correct?
Yes.
And in your previous statement, you said that you had served in a lab for 10 years. Is that correct?
Yes.
Thank you, Your Honor. I have no further questions, and I would like to save the remainder of my time for a possible redirect. I mean, a recross.
That is your right. Will there be a redirect?
No, Your Honor.
Thank you. Seeing that there was no redirect, there will be no recross. Witness, you may step down. Prosecution, do you have any further witnesses?
No, Your Honor. The prosecution rests.